and then so just again, the example you gave was really, really good, which is you're a logo and a graphic designer, and you create logos, and it's not unusual for people in that industry to use Canva and other things to pull in images. Right. When you pull in all those images, are you really the original author of the image, or are you using the electronic intelligence to augment your final product? Right. And so, this again, like I said, it's going to be interesting. It's going to be interesting. I we'll put the link of the case in this episode so you can check it out. Apparently, this is going to be resolved sometime maybe by spring of 2006. That's at the federal court level. My thinking is that there has to be a balance between what is considered to be an AI input in content creation. Right. Like so we need to get a better understanding, because if AI just generically is defined as a computer assisted intelligence to augment your work,
you have to clearly define
then I'm telling you that a lot of the work we're doing already, we've already been having AI. And so you can this is why I think that I am curious as to how the law is going to decide.
The law has to clearly define what they have to make a separation between the chat GPTs versus regular computer software. They just have to make a line and say, okay, chat GPT is defined as this prompt based AI generation software versus where you're in front of Adobe Lightroom and you're actually moving the mouse because you're still doing AI. I mean, if you're using a mouse, there's in Lightroom, there's literally an auto feature. You click on auto, it'll automatically enhance the image for you.
So at that point,
did you do the work?
Did you exactly? And so if you're saying that AI generated images cannot be protected, then it means every artist who's sitting down there in front of a computer, your
poster is not protected as a trademark.
Nope.
This a lot of stuff. Okay, let me throw this one at you. How about this? You're on vacation with your kids, and you're trying to take a picture, you can't, so you see that lovely lady walking across the street. Hey, can you take a picture of us? You give them your phone, and she takes a picture of you, and you take that picture, and then after you sell it to Expedia, now they're using it, and you're getting paid royalties. Can that lady be like, I took that, according to this podcast that I watched, if a monkey snaps a picture, that monkey owns a photo. So I took that picture. Do I have a claim?
Yes, you do. But here's
this is crazy, guys. Are you listening to this? Anybody who goes on social media, any model who's screaming, the picture of me, it's mine. It's not yours.
So here's the thing. Yes, you have a claim. The only difficulty with that claim is that, did you know that
did you plan to
own that, right? If it was not your intention and you were just you're volunteering your services to press a button, it's going to be a hard claim to make. Why? Because you literally are using somebody else's equipment to snap a picture, which again contradicts what I said earlier, which is that the monkey who pressed the shutter owns the picture. But if I say to you, hey, can you take a picture of me? And you didn't negotiate any price,
right,
and you didn't negotiate, hey, if I take the picture of you, I'm going to own the copyright. Technically, you don't have that right until you can, the point is, if you go to court of law, it's like, what do you think was going on when they asked you to take the picture? Well, I felt like they were asking me to create something. If they were asking you to create something, what was your response? Did you say yes, you're gonna, Because technically, if I ask you to do something, you do it, out of your own will without me forcing you. In other words, there's a difference between you walking around by the beach and I take out a knife and go, take the camera and take a picture of me and my girlfriend, else I'm going to stab you.
Right.
That's different from, can you please take a picture of me and my partner?
Yeah.
And you say yes.
Yes.
So you have consented, and unwittingly, you have also surrendered that right without negotiating anything. You may claim that. Let's assume, though. Let's even make it more complex. Let's assume that you are this world famous Fresh Anderson, and you have your camera gear on you, and I know that you are Fresh Anderson, and I know you're good at photography. And I asked you to take a photograph of me. And instead of you taking my equipment, you took your own camera and took the photograph.
Right.
Right?
It's a little different, yeah.
Now, you actually...
Is there a responsibility as a professional to inform anybody that you're about to take a picture that this is a photo that I will own, or this is a photo that is going to be used for commercial purposes? Like, is there anywhere in these cases that a judge will ask, at what point did you inform the customer that they do not own this photo?
So,
like in this example, let's say I am that person. I'm walking down the street. They don't know I'm Fresh Anderson, the photographer, but they just want me to take a picture of them on the beach in the sunset. They say, "Hey, Fresh Anderson, can you take this picture?" Is it my responsibility? Like, I'm a professional photographer, so even though I'm using your phone to take this camera, I own this photo. Do you still want me to take it, or can I just take it and sue them after?
The first scenario, actually, it's more plausible. I mean, more practical. Right, and again, here's the thing. That's an element of clarity that needs to be expressed at the time of the transaction.